I'm Jim Astrakhan.
And I'm Donna Thomas.
And we're from Astrakhan, Gunston, Thomas in Baltimore. Our website is agtlawyers.com.
And we are here to talk about copyrights today. So, Jim, you've been practicing copyright law for 30 some odd years?
Many years.
Many
years.
Okay, well, we'll start with some basics. So, what is copyright?
Well, copyright is a series of exclusive rights that people have in original works that they have created or that have been created by their employees for them. And that's sort of the key. Created by their employees for them.
Okay, I get this question all the time. So what's the difference between a copyright and a trademark?
Well, a copyright is basically a monopoly that another person other than the copyright holder cannot use in most instances without permission. It is an exclusive right that's possessed by the copyright holder. A trademark is nothing more than a designation of source that belongs to the trademark holder, but many people can use that designation of source for a lot of different reasons as long as they do not use it in a manner that causes confusion or is likely to cause confusion. So really what we're talking about is an exclusive right in original works, such as sculptures, architectural works, writings, and that sort of thing, choreographies.
Okay. Computer software.
Computer software. There are a number of categories under the Copyright Act.
Okay. All right. So
and just to go one step further, it does not include systems and methods and processes. So, for example, a recipe or a game would not be copyrightable because these are processes or methods of doing things. Facts are not protectable because they're discovered, they're not created. It doesn't require a lot. It's not like a patent where it has to be unique. This just has to be original to the author.
Okay. So how does copyright come to exist?
Well, copyright comes to exist as soon as the work is created and fixed in what is called a tangible means of expression. It can be perfected, and I use that term loosely, by registration with the U.S. Copyright Office. But you do have a copyright once you fix the work.
Okay. So what do you mean by fix the work?
Well, you write it on paper, you type it into a hard drive, maybe you create a sculpture on a sand table.
You take a photograph.
You take a photograph.
Okay.
All of those sorts of
right,
things. You tape record a broadcast, for example.
Okay. And you don't need to have a registration in order to claim copyright?
You do not. But you have to have a registration in order to avail yourself of a U.S. District Court or other court to enforce your rights in the copyright.
Okay. So what other benefits are there to copyright registration?
Well, the primary benefit is the ability to enforce your rights, as I just mentioned. But in addition, if you register within a statutory period of time, normally 90 days after first publication, you're also entitled to claim in the case of infringement what are called statutory damages. And you can also claim attorney's fees if you have to enforce your rights. And those two rights, statutory damages and attorney's fees, go a long way towards trying to resolve a dispute over whether or not somebody has infringed your copyright. And infringement simply means using your copyright without permission, or your copyrighted material without permission.
Okay. And are you automatically entitled to these statutory damages and attorney's fees, or is it something that's discretionary with the court?
Well, that's right. It's discretionary with the court. And the courts are granting attorney's fees more and more, but the amount of the statutory damages is within the discretion of the court. So if you can show that the infringement was willful, meaning that the person was quite aware that they didn't have a right to the copyright, but they took it anyway, it wasn't their work and they took it, then the statutory damages can be high.
Okay. All right, so what are the rights that a copyright holder has?
Well, the right that the copyright holder has is to reproduce the work, to publicly perform the work, to create derivative works, which are works based on the work. So, for example, the copyright holder to a screenplay, the copyright holder to a novel would be able to create a screenplay or license somebody to do that, and so forth. Those are the large ones. There are 5 or so under the Copyright Act.
Right to distribute.
Right to distribute.
Right to Perform, create modifications, reproduce, and display. The right
And to display, publicly display, correct. And all of these terms are, subject to interpretation in court decisions.
Okay.
But that's right.
All right. So.
And they are also subject to fair use, a topic that we'll get into at a later time. But that would be an exception to the copyright holder's ability to absolutely control the use of his or her work.
Okay. So who owns the copyright? How do you acquire ownership?
That's a great question, Donna, because generally the owner of the work is the author, the person who creates the work, the person who writes the poem or the short story or paints the picture or takes the photograph. But if an employee has created the work within the scope of her employment, then her employer owns the work, regardless of whether or there is an agreement. This is what the copyright law says. And so that term, scope of employment, has pretty well been defined by the Supreme Court of the United States. An independent contractor, somebody you might hire to come over and photograph the kids or to photograph your wedding, is not an employee in the scope of acting in the scope of employment. And so that person would own the copyright to the photographs that he or she took. And that person would license to you the use of those photographs and the right to copy those photographs.
Jim, what is a work for hire?
Well, in the most general terms, a work for hire is a situation where you engage a freelancer to come to you and to create some sort of copyrightable work. And then what you do is you get a transfer of ownership in writing. And generally that's called a work for hire.
Okay. There are categories of specially commissioned work for hire in the Copyright Act,
yes,
right?
That's right, there are.
But can you make any work a work for hire?
You cannot make any work a work for hire. They have to be in one of the 9 enumerated, do you like that word? Categories. But that doesn't mean that if it's not within the 9 enumerated categories, that you cannot contract with the independent contractor to transfer ownership of the copyright to you.
Okay.
So that's what you do, and oftentimes you'll see contracts that say, this is a work for hire, I transfer the rights to you, but it's really not a work for hire because it's not an atlas or a compendium or a test. And so the contract goes on to say, but however, if it's not a work for hire, I hereby transfer rights to you.
Okay. All right, so let's take a common problem that we hear from our clients. Somebody hires independent contractor for their business. Let's say they're creating a software program to do back-end operational work for the company. So, maybe it's a customer management system or something, and there's no agreement that discusses copyright. The agreement says, this is the scope of work. Here's what you're going to create. Here's what I'm going to pay you. The job's done. They get paid. We're working with the software, and 6 years later, we need to hire somebody to modify the software. Do we have the right to do that?
We may, because it really depends on what our license looks like, and that is to be determined. So, what we're dealing with now is we're sort of out on a high wire balancing in terms of trying to convince somebody that when we entered into a contract for you to create software, there was implied all of the rights we needed to enjoy the software, which would include fixing the software, reproducing the software, and so forth. That's something to really be avoided, and we've been down this road more times than we care to remember. And so that contract, when it was entered into 6 years earlier, should have contained 2 very important things. One, a transfer of ownership. When we pay you, you're going to transfer ownership to the copyright. And it may well be that buried within the work that you gave us is code that you have that you use over and over again, but we need to know that. And we need to have a perpetual paid-up license to use that for any purpose. And while this is beyond the scope of this conversation, the other thing that contract should have required was an indemnification, so that if you as a third-party contractor gave us code and we're using it and it turns out that you infringed somebody else's software, you need to hold us harmless for that.
Okay. So if you don't deal with these issues in a contract, you may have an implied license to use the work for what everybody understood the purpose was, but it gets a little gray as to what the scope of your rights are to be able to modify it, sell it, if you sell your business?
Well, that's the problem. You know, you use the term, you may be able to use the software pursuant to the rights that everybody thought we had. That's a factual question again.
Okay.
That's the kind of question that a jury or a judge may have to determine. You know, what rights did we think we had? What rights were you conveying to us? What rights do you think you reserved? Because under the example, there's nothing in writing. And so
Right.
all of these factors have got to be determined by what may have happened when you wrote the software 6 years earlier. That's a problem. You want to avoid that problem like the plague. And you just mentioned also a situation where you might sell your business, and this may be important software to you, and the buyer, in doing its due diligence, is going to be asking you, the seller, for some sort of title to show that you own this software.
Right.
And if you can't show that, that's a real problem if this software is important to the sale.
Can you transfer copyrights verbally?
No, you can transfer licenses, but you can't transfer exclusive licenses.
Okay.
So you can transfer non-exclusive licenses, but you can't transfer ownership unless it is a signed writing, which of course should identify the copyrightable product.
Okay.
What do you think about that?
I think it's pretty important to get a signed writing when you're hiring somebody, an independent contractor, to create a work product for you.
Yeah, in our experience, as you know, this can be a mid-six-figure problem for a client. It could make the difference between, break your business, make your business.
Okay.
I'm Jim Astrachan,
I'm Donna Thomas.
and we're from Astrachan Gunston Thomas in Baltimore. Our website is agtlawyers.com.